I'll now call the second case on the 9 a.m. docket, 123687, State of Kansas versus Joshua Sinnard.
Morning, Your Honors. May it please the court, Corinne Gunning, appellate defender appearing on behalf of Joshua Sinnard. Madam Chief Justice, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted. Thank you.
For the reasons that I've stated in my petition for review, I would request that this court vacate Josh's conviction based on the speedy trial violation, or on the alternative, reverse his conviction and remand for new trial errors. Josh maintains that the problems in this case started well before the trial. With the speedy trial violation. The state's attorney and the court seemed to be pretty clear early on that there was a particular case that took priority in their minds, and they worked to make that case a priority at the expense of Josh's statutory speedy trial rights.
What's wrong with that? I mean, if you've got multiple cases, you've got to prioritize one over the other, right? And the district court explained its rationale for doing that. I guess, how does that implicate? I understand how it could implicate the statutory speedy trial timeline, but in terms of the crowded docket exception being invoked, I don't see how a district court's decision on which cases get set, first, second, third, whatever, undermines the crowded docket exception that was invoked here. Can you help me understand that?
I certainly will endeavor to try. The position is that I fully understand the reason for the crowded docket exception. I recognize the trial courts are very busy. They have lots of cases set, and they do have to balance their docket a little bit. What I take issue with in this case is that aside from a couple mentions of it, it seemed that nobody was really concerned about Josh's speedy trial rights. We have 180 days. It does feel weird to be arguing about speedy trial at this time, but at the time, there was 180 days in which the court had to bring someone to trial if they're out of custody. Many of the people that we were talking about in their cases today are out of custody. Both Mr. Ross and Mr. Sinnard and Josh were at the end of their 180 days. I would expect that we would be talking about, okay, how are we going to set this so that we can respect both of these people's speedy trial rights? Josh was willing to waive 9 days. I think we would be in a very different position if he hadn't made that waiver. But he was willing to waive those 9 days to go to the October 28th date. Already at the end of his 180 days, he went to 189 days, and they still set him second. And then when Jordan Ross comes in and says, I don't have my client, my attorney.
Can I stop you there? So at that point in time, when he gets set for October 28th, the second setting, he was the second setting because yet another case was already set on that date, right?
Yes.
Was that like the Potts case or something?
Yes.
Like that? Okay. All right. I just wanted to make sure. So your second setting there, do we know what happened to that case?
I am not certain what it did not obviously go on October 28th. That was when the Ross trial went. So I do not know what happened with that.
And if I'm hearing you, your real objection is that whatever happened to Potts, it went away rather than moving Mr. Sinnard up to the first slot, they put the Ross case into that first setting.
Putting Mr. Sinnard functionally third on that day on his past his 180th
or second.
Potentially, yes.
Yeah, which was where he was originally.
I do know that Mr. Potts did not plead before that day. His case was not resolved before October 28th. But within this, I mean, I just feel within the crowded docket exception, I recognize the need to balance these very busy dockets. When the court moved Josh's case, contrary to what the Court of Appeals said, it wasn't to accommodate the parties, it wasn't to accommodate witnesses. Jordan Ross also was willing to waive his speedy trial date into the first part of 2020. All of this happened at the end of 2019. He was willing to waive his speedy trial rights into January, February 2020, which Josh had indicated he was not willing to waive. And so I think that also puts us in a different posture when we have two people at the end of their speedy trial rights. How are we going to balance that? Well, we have one that's willing to waive, one that's willing to not waive.
Where is that in the record? For some reason, I didn't see that.
I added the transcript of the hearing that Jordan Ross had. I believe it is volume 30.
Okay.
What, isn't it appropriate for the judge to balance more than just the wishes of the defendant as to when he wants to be tried? I mean, there are witnesses, there are schedules, experts that might be coming in. All of those things can properly be considered by the court, correct?
Yes, and I think that was something that the court looked at here, and all of the state's witnesses, all of the defense witnesses were able to accommodate a later date besides that October 28th date. In fact, defense witnesses, the defense expert in this case, Mr. Overstreet, he said, well, she has conflicts that week. I guess we can try and work it out. And Mr. Overstreet himself said he wasn't going to be available the first day of that trial week. And so the way that the balancing looks is not that the court was trying to figure out how are we going to accommodate everybody in this case. It looked like, well, we have all the state's witnesses, we're going to go, even though he was aware that one, defense witnesses may not be able to be there. Defense counsel was not going to be there first day, one of defense counsel, and the client was willing to waive his statutory speedy trial rights further. So the balance did not seem really very balanced.
Wasn't the other case older?
I don't know exactly when it was charged relative to.
Are we applying an abuse of discretion standard?
Yes.
And is your position that abuse of discretion was violated because of a legal error or because reasonable people wouldn't agree with the trial court's decision?
My position is that both. I don't think it was a proper application of the crowded docket exception.
And what's the rule of law that was violated? What was the legal error in a capsule? Really, the way that I've stated in my briefing petition is that when a court creates the crowding, which is what happened in this case, the court created the crowded docket. It wasn't a situation where, okay, like we come and we've got 3 cases set. It's, I know that these 2 cases are set. I'm going to set one ahead of those. When the court creates the crowding of the docket, the crowded docket exception is not appropriate for them to apply.
Your argument is it's a manufactured.
Yes. Yes.
And I guess I'm still having trouble, and I don't mean to interrupt your questioning, Chief. How is it that it was manufactured? The court has so many cases. They are all set for jury trial. How is that a manufactured crowded docket kind of exception that kind of creates the crowded docket and kind of does? I guess I don't understand that when 5 cases are set, and those of us that's been there, that's the reality. You have so many cases and you set them and try to work them through.
Yes, and it
And I really do appreciate the position of district courts and particularly I know that trial counsel are trying to work through things on a regular basis, but typically Josh in this case knew he was going to be second up on that day. His counsel was going to be ready. He was ready to go on that day. Then he gets a motion to change his trial date. And without him being present, they've moved another case ahead of his. And so typically in district courts, I recognize that we have this, but they know that they're going to be, I'm third up, I'm fourth up, I'm probably not going to go. When you are third up versus fourth up versus first up, it changes your trial preparation. He knew he was going to be second up, possibility he was going to go. Without his presence, they moved another case in front of him and said, and the judge was told, you can probably, just use the crowded docket exception once we move Jordan Ross. And that, I think that's my biggest problem in this case is, and I know that Danny Queen's case was very different, but what happened in that case is they set Danny Queen's case outside of speedy trial time, said, is everybody on board with this date? And then when they realized it was out of speedy trial time, they said, oh, but we will go back and we'll find a reason for why we moved him past that date. And again, the circumstances are perhaps dissimilar, but in that case too, the court had a crowded docket. They had a busy docket, and then those are the dates that worked for them. It just happened to be past 180 days. In this case, they had a crowded docket. They moved another case in front of Josh's case and then said, oh, and now we have a crowded docket on that date that we're going to use to move him again. And so it feels like the court is looking for reasons to justify the decisions that it is making in prioritizing its cases, rather than saying, okay, we all show up on October 28th. This case is going to go. These other cases, we'll see how fast this case resolves. It was a week-long rape trial, so it probably wasn't going to resolve quickly so that they could do 2 cases that week. But it wasn't a typical crowded docket situation that I think most district courts see. And I think
For clarification, because I'm not as familiar with the record as you are, was Mr. Ross in custody?
Ross was not in custody, no.
Mr. Sinnard was not in custody either.
So both of them had that 180-day clock, and both of them, frankly, were at the end of it.
Basically, it's your
180.
point that the crowded docket exception was utilized after they realized they said it that violated the speedy trial. That's basically your point.
Yes.
Thank you.
Can I
And-
ask you then, I'm sorry, I don't want to close up your arguments on speedy trial, but I did want to ask about the evidentiary objections too. So am I interrupting your closing on that?
No.
Okay. So we've released the decision in Timley, all right? And I'm sure you're familiar with that decision. What differentiates the testimony here? Well, I'll tell you what I think makes it different is at least there was some discussion about how cell phone towers connect with cell phones essentially here. But I don't want to put words in your mouth. I'm trying to understand what specialized knowledge really converted the detective's testimony from lay to expert, in your opinion here.
The way that I understand the court's opinion in Timley, kind of following other courts, is when a detective says, okay, here's where the cell phone connected, here's the towers. If you read cell phone records, we can see the towers they connected to. We can map where that happens and find out where the cell phone was relative to whatever incident happened in the case. And that doesn't require specialized knowledge because it's just mapping, it's just showing where things are. In this case, the detective testified about why cell phones connect or don't connect to certain towers. He testified about IMEI and IMSI information, which I believe is specialized knowledge about how cell phones work and what they do. He testified about particularly as well, why Josh's cell phone didn't connect to a tower for a period of time. So it connected this time and then the cell phone didn't connect to any towers. And so he explained why he believed it didn't connect to any towers. So he was giving specialized knowledge about how Josh's cell phone works and why it would or wouldn't connect to particular towers, why it would or wouldn't give a signal, which is more than just saying, okay, here's where we saw him at this time and here's where we saw him at this time. He did give both pieces of information, I mean, clearly, but I think he went beyond what this court said was appropriate in Tim Lee for lay testimony.
Questions? So your position is that the speedy trial docket consideration must be the last arrow in the quiver and not just one arrow or tool that the court considers.
Yes, I would say that it's the court's obligation to bring someone to trial within the speedy trial deadline. That our legislature had set a speedy trial deadline. Courts are required to bring them to trial within that time. And so I think that should be the court's priority, balanced with their docket, but the priority should be respecting the rights that are set forth by the legislature.
Is that in the statute? The last?
I would no, the statute sets forth the time periods and then there's a myriad of exceptions to it. But I think the primary is you must bring the person to trial within 180 days that they are out. And then here are exceptions to that rule. So I would say just as far as reading the statute, the primary consideration is the speedy trial time. Unless.
So you want us to make that law, that it has to be last as case law?
I don't necessarily think that the court needs to make a particularly bright line rule on that. Every speedy trial case is factually. And so in this case, I think the court can find that in crowding the docket and as manufacturing a crowded docket, they don't then get the benefit of the exception. So unless the court has other questions, I would again ask that the court vacate Josh's conviction and relieve him from any further liability in this case based on the speedy trial violation, or in the alternative remand for new trial based on the trial errors.
May it please the court. Good morning, your honors. Assistant District Attorney John Simpson appearing on behalf of the state. Unless the court would otherwise direct, I'll probably focus on the speedy trial argument. And if there's time, touch on the expert. So I understand defendant is arguing there was an abuse of discretion, one, because there was a legal error committed, and second, because no reasonable person could agree with the district court's decision to prioritize Ross ahead of Sinnard's trial. Concerning the argument that there was a legal error, state understands the complaint essentially to be that legally the crowded docket provisions terms did not permit the district court the discretion to move Ross to October 28th. And then when Ross proceeded on that date, use the exception to reschedule Mr. Sinnard's trial to November 12th, particularly because Mr. Ross was willing to waive his speedy trial rights. And the state does not believe the crowded docket provisions terms are so narrow. By its terms, the provision provides that a trial court may extend the time for trial if, quote, because of other cases pending for trial, the court does not have sufficient time to commence the defendant's trial. Now, nothing in that language shows the legislature intended that as the defendant effectively suggests, that the other cases in question be limited to only other already scheduled cases pending for trial, or only other cases pending for trial wherein defendant has already asserted, the right to a speedy trial. And I would point this court particularly to the Court of Appeals decision in State v. Dean, That's at 42 Canap second 32, pages 35 to 38, where they ruled that the provisions terms, or whether they recognize the provisions terms, do not even limit other cases to only other criminal cases. And so in that case, the court held the trial court was permitted to use the exception to prioritize trying a civil case, which could have been rescheduled over the defendant's criminal case. Ultimately, the only limit the provision places on the type of cases which may support the exception is that their status be pending for trial. And the ordinary meaning of pending, according to Merriam-Webster Black's Law, is essentially that awaiting. So if the trial court determines that it lacks sufficient time to try defendant because of another case awaiting trial, the crowded docket provision allows it to extend the time for defendant's
You're
trial.
saying effectively a district court that has a really complicated civil case with motions for summary judgment pending and has to produce a, I don't know, 100-page written order, could use that as the reason under the crowded docket exception to postpone a criminal trial.
I believe the statute legally permits that. I think the hurdle for the trial court in that instance
It might be unreasonable. You might
would be
get,
that they would have to prove that all reasonable person,
but it wouldn't be an error of law.
correct. And so in this case, Ross, of course, was an other case. It was awaiting trial, and the district court obviously could not bring Ross and Mr. Sinnard to trial both on October 28th. So whether or not the defendant was on the October 28th trial prior to Ross, or whether or not the district court could have moved Ross's trial to a later date he was willing to accept, Ross was still another case pending for trial that left the district court without sufficient time to try Mr. Sinnard.
What do you make of the argument that I was reviewing from the appellant's briefing, that if you just look, and this may be an error of fact, sort of fall into that bucket, but that there were in fact dates that the court acknowledged that the case could have gone to trial on August 19th or September 3rd. And I think that was communicated at the July 23rd hearing.
So I think in this situation, we have to take a step back. The speedy trial deadline originally was set to expire the October 19th. Defendant waived speedy trial from October 19th to the 28th. So under this court's case law, the state did not have to, justify bringing defendant to trial prior to that date. And in this instance, when the crowded docket provision was actually invoked by the court, those dates had already passed. The only dates that the court had available to look at that time were, November 4th, October 28th, which obviously couldn't proceed on that date. November 4th, which was crowded by another criminal case. And then the first available date after that was the date he received, November 12th.
So at that July 23rd hearing, the district court was sort of helping the defendant make a knowing and voluntary waiver by explaining that you could have, hey, if you don't waive, this is what the calendar potentially could look like. But given that information, there was a waiver. So then those dates sort of go away.
Correct, Your Honor. So I guess briefly touching on the argument that it was an unreasonable decision made by the trial court. The Ross trial involved, the only date the Ross trial could proceed, the only date the district court had, the 10 to 13 estimated witnesses for the Ross trial had available, including a defense witness who had a admittedly quite full calendar, could try Ross, was on October 28th or over 6 months later in February 2020. And in Ross, it was an older, I think roughly a year older criminal case. It was a higher level felony. It had already been moved twice. And the district court recognized that further delay put added stress on the minor victim in that case.
What about the argument that he was willing to waive speedy trial? I mean,
Well,
what do we do with that?
I think, well, again, legally, it's a non-factor. And I guess I would point to the current version of the statute, which obviously wasn't controlling at the time. But it was six factors which the trial court should consider in scheduling trials in the context of the delay COVID has caused the courts, and only one of those factors is the assertion of speedy trial.
This was all pre-COVID, correct?
Correct.
Clarified. Thank you.
So turning to the expert testimony issue, I think the Court of Appeals properly reasoned that Fleming, Smith Parker, two of its decisions, and this court's decision in Timley suggested that under those cases, Detective Slifer's testimony required no specialized knowledge or expertise beyond that which he possessed.
He was testifying from the phone records, right?
He was testifying primarily, if not exclusively, from the phone records.
Did the phone records he have identify the cell towers? Like my phone records, I don't think do that, but.
So the records in this case identified the location of the servicing cell tower. They did not, as in Timley and either Fleming or Smith Parker, one of them, identified the particular sector of that tower, which the signal, so they didn't narrow it to location oriented to a particular.
Wait, so will you say that again? I'm sorry.
So we identified the records identified the location of the tower that serviced the defendant's phone. They did not identify a direction that the signal was coming in to the tower from. So
But those records said, like I'm going to use a layperson's term. The record showed which cell tower was pinging from his phone. Yes or no?
correct.
Okay. And so even if he hadn't testified, I mean, they could have looked at the records and said, oh, this pinged this cell tower, this pinged this cell tower.
Correct. And there were the records accompanying the records were a set of instructions that the cell service provider included. And those instructions laid out much of what Detective Slifer was explaining to the jury.
Did it explain why for periods of time the cell phone didn't connect to a tower?
So not to interrupt. Sorry.
Okay, no, go ahead.
So I think there's a distinction to make. The testimony that I think Mr. Sinnard is referring to was not an opinion on why his phone did not connect to a particular tower. It was a general statement about why there would be no records outside those contained in the exhibit. So the exhibit essentially, and this is what the exhibit itself said, includes information only for calls made, non-roaming calls, and for standard text messages. Any use of the cell phone or non-use of the cell phone outside that would not be recorded.
Help me here. Why doesn't that require some sort of specialized knowledge?
I
As
don't,
opposed to me up there testifying what my records say. It seems like this is, I know we're kind of in this gray area, but this seems to lean to me towards requiring some sort of specialized knowledge on the way cell phones operate, how they're received, what towers, what they do. Is that just common knowledge?
I'm afraid, well, first of all, I'm not probably an appropriate candidate to represent what the common man knows or woman knows about cell phones.
What do you?
But assuming, for example, that knowledge is not something the ordinary or layperson would just happen to know, the qualifications that the state established for Detective Slifer in this case provided.
I understand it. So were they trying to qualify him as an expert? He did have some specialized knowledge. He
They did not
attended these-
qualify him as an expert to provide opinion testimony. But they qualified him to lay foundation for to contextualize the records themselves.
Was the
Go ahead.
Was the opinion or the testimony about the way that the technical ways that cell phones and towers interact, or was it about the records?
So his testimony was primarily about the records, but he made an unobjected to and an objected to general statement about how cell towers, cell phones and cell tower signals generally interact. And that statement was essentially one of fact, not an opinion. It didn't apply any principles to the records in this case.
I'm just trying to understand. A minute ago, I think you said that his testimony was that anything the phone does outside of calls and direct text messages is not captured in the records. Did I remember that correctly?
Correct.
That strikes me as an explanation of the records, not the technical side of how phones and towers work.
I believe that's a fair characterization. And I think that's, again, what was reflected in the instructions, explaining how to read the records.
And was there additional testimony that was about the phones themselves and the signals that go back and forth, or was it just about what gets captured in the records?
I don't believe there was any testimony about how Sinnard's phone, particularly his particular phone connected to a tower. I think it was just the records say this tower serviced his phone. The detective never testified that the record showed the exact location of the phone. He never testified that particularly never testified they showed the exact location of defendant. He simply testified this is the tower that serviced, and the trajectory of those towers aligns with the victim's testimony about where she was and when with the defendant.
Any,
Want to know whether the state has any preservation concerns with the arguments that are being made on appeal concerning the detective's testimony with cell towers versus the argument that was made.
Well, I think the state does have preservation concerns. I think the Court of Appeals recognized that we're talking about only one overruled objection. And so to that extent, I think that's the only issue this court should consider. But I will recognize the Court of Appeals opinion was never expressed in saying, we are applying the contemporaneous objection rule, only this issue is preserved. But again, it certainly recognized that the only objected to, only sustained objection was to one instance of Detective Slifer testifying about his earlier testimony about how cell towers generally, or how cell towers and cell phones signals generally interact. I guess I would quickly touch on the instructional error issue for the court. In this case, when this court assesses instructional error claims, it considers whether the instructions as a whole properly and fairly stated the law and were not reasonably likely to mislead the jurors. And the case that Mr. Sinnard relies on, Jackson, there, the instruction included no mention whatsoever of the requirement that the state need to prove that defendant acted knowingly. And so with that instruction, the jury was necessarily left with the misimpression that to establish the charge, the state had only to prove particular acts were committed under particular circumstances, and not that those acts were committed knowingly. But here, the instruction not only gave the jury the elements about which acts and which circumstances the state needed to prove, but also stated the state must prove the defendant committed the crime knowingly. And so that instruction told the jury not only what conduct the state needed to prove, but also that defendant needed to prove defendant engaged in that conduct knowingly. And I think the distinction that defendant draws in the petition, distinguishing between the enumerated portion of the instruction as the elements and the non-enumerated portion that information as purely definitional is not one the jury would make. The jury was instructed, it was its duty to consider and follow all the instructions. It was told the state had to prove each of its claims beyond a reasonable doubt. And with respect to the state's claim that defendant committed commercial sexual exploitation of a child, it was told that the state must prove the defendant's conduct. The defendant committed the crime knowingly. So I don't think there's any error here with the instruction. But of course, should this court find error, there's no clear error because the jury obviously was instructed that it had to find defendant's conduct was knowing. If there are no other questions, the state would just submit that the Court of Appeals correctly found that a properly instructed jury convicted Mr. Sinnard without relying on inadmissible evidence at a timely trial. Would ask that this court, from the Court of Appeals decision, the district court's actions and Mr. Sinnard's convictions.
Questions? Thank you.
On my rebuttal, I would like to maybe take things in reverse order with the elements instruction. In this case, in the Court of Appeals decision, the court faulted appellate counsel particularly by saying that the instruction was legally inappropriate because it had a definition of the culpable mental state on the same page. I would maintain that the elements instruction is still legally inappropriate without that element of the mens rea included in it.
You need knowingly in number 1 and number 2 on that jury instruction, right?
Yes,
That's your argument.
yes, the argument is that it should be included as an element, not merely the definition doesn't provide the element.
Well, wasn't that the very instruction the defense counsel proposed?
Yes, and I was before this court a few months ago as well with this with instructional questions. The question is not whether or not he proposed it; it's whether or not in him proposing it, he caused the district court to make a different decision. Everybody was on board. In fact, the instruction that was given is what is in PIC. I maintain that the PIC instruction is legally inappropriate. I don't think that him asking for it enticed the judge to do anything different than it was already going to do.
Well, the standard pick didn't include the knowing definition at the time, right? So you can arguably convince the judge to deviate from pick.
You can, and it is common practice. I'm sure this court is aware of including the definition of the culpable mental state alongside the elements instruction. It is a different instruction within PIC, but the PIC instruction of the elements for commercial solicitation does not contain the knowing element. And so just by him requesting this, I don't think that he caused the judge to do anything else than it was already going to do.
But I guess the panel didn't address invited error, and I don't believe the state cross petitions. So does that limit our ability to address an issue like that, or?
My perspective is yes, that this court only has before it what it has been petitioned. Obviously, this court can and does often go outside that. I would say with the preservation concerns, I don't think any of the preservation concerns that the state raised below are also before this court. The Court of Appeals decided some of these, the questions on the expert testimony were preserved. They decided that there was no cross petition on the court's decision that those claims were preserved as well. So I don't think that any of the preservation questions are before this court as well. And with that, I see my time is up. If nobody has any. I would just ask again that this court vacate Josh's conviction based on speedy trial violation or remand for new trial.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.